Okay, Tyson. So, Mr. Tyson, you said that you did not go to Secretary of State's office and you're not planning on getting your driver's license?
No, I do plan on getting it. I just had to pay some fees first to go in order to go to the Secretary of State and get my permit again to take my test.
Have you paid the fees?
Yeah, I just have to go to the Secretary of State now to retake the test, and then I have to take my road test, and then I can have my license.
All right. Let's adjourn it out then, Katrina, till August 3rd. We'll give you a little time to get that done, Mr. Tyson. Let's get it done.
Okay.
What time on August 3rd, Katrina?
Your Honor, is he hiring an attorney or is he going to be in pro per? I'm sorry.
What are you going to do, Mr. Tyson? It depends on the time slot we give you.
Represent myself.
Okay.
8:15, Your Honor, on August 3rd.
August 3rd at 8:15. We'll see you then.
I work until 9.
Well, you'll just have to step out of work for a moment because I could make you come here live.
Yeah, we ride a bus though, and there's no service. Like on my way home, and I get off at 7, but the bus don't make it home until 9.
All right, Katrina, can we give him another time slot?
One moment, Your Honor. 10:15, Your Honor.
10:15, Mr. Tyson.
Okay.
Thank you. Recalling the cases of the people state of Michigan versus Ian Silverstein, 210728, 210528. Counsel, identify yourselves for the record.
Thank you, Patrick Swinsky for the people.
Peter Durant on behalf of Ian Silverstein, who's appearing from the Midland County Jail.
All right, Mr. Durant, you had requested an opportunity to speak with your client. Have you had an opportunity to do that?
Yes, I have, Your Honor, and I believe we've reached an agreement with the prosecution.
What is the agreement?
The agreement is for the first domestic violence case. Let me pull up the case number for that. Don't know why my computer is being frozen right now, but it is against. Apologize, Your Honor. I don't know why my computer is being so slow. However,
okay.
There's the two domestic. There's the assault case, and then there's the domestic violence case.
Right. So the assault case is 210528. That's the assault case, and the domestic violence is 210728.
Understood, Your Honor. So for the assault case, the plea would be to a count of disorderly conduct jostling, and then the domestic violence case, myself and the prosecutor agreed that we would recommend SAA to plead to the domestic violence. And then if the disorderly conduct jostling, I don't believe that impacts the SAA.
All right. Mr. Schwinsky, is that the offer?
It is, yes. The disorderly and the assault file and SAA and the DV file.
Okay. Mr. Durant, may I address your client regarding his decision?
Yes, Your Honor.
Mr. Silverstein, your attorney is recommending that you plead to a disorderly person in the assault case and plead guilty to the domestic violence, and there would be a recommendation by the prosecutor for you to receive the spouse abuse deferral. So if everything went according to the attorney's plans and you did everything you were supposed to do and didn't do the things I told you not to do, at the end of the day, you would have one conviction for the disturbing the peace. It wouldn't be a public conviction for the domestic violence. Is that what you understood?
I understand that, yes, sir.
Your attorney is recommending that you accept that offer. Are you planning on following your attorney's advice?
I am indeed.
All right. If you could please raise your right hand, I'll have you sworn in. Do you solemnly swear or affirm testimony you're about to give is the truth, whole truth, nothing but the truth, so help you God?
Yes, sir.
Or you can put your hand down now. Has anyone promised you anything more than what we talked about on the record or threatened you in any way to get you to plead to this when you really do not want to?
No, sir.
Are you right now under the influence of any medicine, drugs, or alcohol that's confusing you?
No, sir.
If you enter this plea, you'll be waiving the rights to a trial by jury, or if you, your lawyer, and the prosecutor agreed, a bench trial, you'll be waiving the right to remain silent, not have your silence used against you, the right to be presumed innocent until proven guilty beyond a reasonable doubt. Mr. Trance, are you appointed or retained on these cases?
Appointed in both cases, Your Honor.
You would be waiving the right to hire your own attorney. Mr. Durance will be your court-appointed attorney, and you'd be waiving the right to represent yourself, waiving the right to confront your accusers, to call witnesses, and to testify. Do you understand each of these rights?
I understand.
You would have to waive these rights in order for me to accept the pleas. Do you waive these rights?
I waive those rights.
How do you plead then in count file 210528SM to an added count 2 of disorderly person jostling? Do you plead guilty, not guilty, or stand mute?
I plead guilty.
On April the 28th, were you at an address at 4910 Art Crest Drive in the city and county of Midland?
Yes, sir.
Did you get into an argument or a disagreement with somebody in that area?
Yes, sir, I did.
It ended up being kind of like roughhousing or kind of a jostling type an event where you were disturbing people's peace and you get into an argument and kind of pushing and shoving back and forth?
Yes, I can agree to that.
All right. Mr. Durance, if I presume that that's true, have I complied with the court rule and had an adequate factual basis?
Yes, Your Honor.
Mr. Swinski, do you agree?
Yes, I do.
All right. I find that the plea has been made knowingly, understandingly, voluntarily, and accurately. Will enter as count 2, which is the disorderly jostling. Count 1, which is assault and battery, will be dismissed. I'm going to set this over for pre-sentence investigation, abbreviated PSI for victim information and restitution, and jail credit for this. I'm going to deal with the issue of bond on both cases, Mr. Durance, after I've taken the plea in both files. So
Thank you, Your
temporarily, I would like a sentencing date if I could, Katrina.
Yes, Your Honor, that would be August 2nd at 10:45 a.m.
All right. So we're going to temporarily adjourn on that file, going to file 210728. Silverstein, I want to remind you that you are under oath still. Has anyone promised you anything more than what we've talked about on the record or threatened you in any way to get you to plead to this charge when you really do not want to?
No, sir.
Are you under the influence of any medicine, drugs, or intoxicants?
No, sir.
If you enter this plea, you will be waiving the rights that I had gone over in the other file. Do you remember those rights?
Absolutely. And I waive those rights.
Okay. How do you plead in this case to domestic violence? Do you plead guilty, not guilty, or stand mute?
I plead guilty.
On May the 23rd, did you go to an address or were you on Waldo Avenue in the city and county of Midland?
Yes, sir.
Were you there with a person by the name of Casey Cole?
Yes, sir.
How do you know Casey?
She is the mother of my child.
And what happened on that day that makes you think you're guilty of domestic violence against her?
We had got into a disagreement, and I allegedly moved past her aggressively and bumped her too aggressively for her liking. I don't know what she said. I don't know what she said precisely, but we'll go with what she said. I got too aggressive. So.
Did you push, shove, or hit her or move her out of the way in a way that she did not want to have done?
Yes, sir.
All right. If I take that as the truth, have I complied with the court rule and had an adequate factual basis, Mr. Durance?
Yes, Your Honor.
Mr. Sherwinski?
Yes, Your Honor.
I believe I have as well. I find that the pleas have been made knowingly, understandingly, voluntarily, and accurately. Will enter in as domestic violence pursuant to the spouse abuse deferral. Set this over for pre-sentence investigation. Actually, I want a full PSI in this case. August 2nd at 10:45 will be the sentencing date. It will be in person. Mr. Durance, wish you issue or request you anything regarding bond?
Yes, Your Honor. I'd be requesting that Mr. Silverstein be placed on a cash bond with pretrial services to make sure that he is not consuming any substances he shouldn't be consuming. as well as 2 no contact orders, once against Casey Cole, the second against Shannon McCullum. Both of them are the victims in this case. Mr. Silverstein has served significant time in jail. I believe that he understands that the court is very serious when it tells him to obey its order, and that Mr. Silverstein understands that he may serve additional incarceration upon the violation of any court order. However, he does believe that he needs to be out and working so that he can have money for fines, as well as to pay for the supervision for any term of probation. Thank you, Your Honor.
Thank you. Mr. Swinski?
I don't have an objection, Your Honor. I know that the court was concerned to make sure Mr. Silverstein was receiving the appropriate services. So as long as the court's satisfied with that, I'll leave any decision to the court's discretion. Thank you.
All right. Katrina, do we know whether or not Mr. Silverstein appeared in jail at the time that I had ordered him to?
Let me look, Your Honor. Give me 1 second. He has served 15 days. He was booked on June 6th, 2021, Your Honor.
What time?
Your Honor, I'm sorry, it does not say the time.
I was there at 4 o'clock. I was booked in about 4:45. You asked me to be there by 5 o'clock.
And you did that?
Yes, sir,
Okay.
I did. I will follow every rule, I promise.
That's what I was looking to see. So the easiest one is when I say go to jail. If you do go to jail on time, then I know that we've kind of reestablished some trust with one another.
Yes.
I'm going to let you out on bond. I suspect that you've had some time to think about behaviors and how to interact appropriately regarding court orders. Would I be right?
Yes, sir.
Okay. I see a much more humble person today than I saw the last time that we've interacted. I'm going to take a chance with you. My probation staff's going to have to be convinced because they're the ones writing the report. The notes that I have said that you weren't very good at getting ready on pretrial services. And they said, you know what, just kind of leave him in jail because it's probably what he's going to get. But the prosecutor is offering the spouse abuse deferral. You can only get that on probation. So you got a lot of proving to do between now and sentencing.
Yes, sir.
So you can do that by getting out, getting back to work, following all the rules, and convince the probation staff. Ultimately, it's my decision, but they write the reports because they know all the details. So I would suspect that you take your new focus and attention and turn it towards getting things done so that when August 2nd comes around, I don't put you back in jail. Instead, we follow the process and let you be on probation.
Okay.
All right. Having contact with either of the victims in this case would be one of the bad things to do. Directly, indirectly, telephone, email, Snapchat, any of those, any mechanism would be bad. I find that sometimes if I leave one off, that people that know more about these different ways to communicate find one more and then I got to add it. So don't make me add one.
Yes, sir.
All right. We're going to reinstate your bonds so that you are going to put them out as a PR bond to let you get back out again. But make sure you make contact with the probation department and follow everything they ask you to do.
As soon as I leave this building, I will be in contact with them.
That sounds good. All right. We'll be adjourned. They can release you. I don't think anybody else has a hold on you, just my 2 cases, right?
I believe so, Your Honor.
Okay. Sometimes people have a different county or a different case that I don't know about. So I tell somebody they're going to get out and then they don't get out, but it's not because of our order. It's some other judge that they don't like me changing their orders. And I don't like to do that. So we're all set. Let's see how we do. Good luck. We'll see you on August 2nd.
Thank you so much.
Your Honor, just for
Yes.
clarification, you do want him back on pretrial services until sentencing, correct?
Yes. I want him back at pretrial services till sentencing.
Thank you.
Okay.
All right. Reinstating all the bond terms. We'll see how he does this time. All right. We're
All
adjourned.
right. Thank you.
Thank you.
Your
Mr.
Honor, Ms.
Branson, I
Peters?
saw Mr. Yes. Well, I saw Mr. Branson and Mr. Dusso here.
I'm waiting for his client to log on.
Okay. Well, then we'll jump to Ms. King's then. Calling case of the People State of Michigan versus Alicia Rose Peters, file 210419 SM. Counsel, identify yourselves for the record, please.
Thank you, Patrick Swinsky for the people.
Thank you, Judge. Kimberly King, Gower Law, on behalf of Ms. Peters, who is appearing via Zoom.
All right, today's time and date set for settlement conference. Has there been an agreement reached in the case, Ms. King?
There has, Your Honor. There should be an offer in the file. My client is going to plead guilty to count 1, domestic violence, and an amended count 2 of operating while visibly impaired. Count 2, OWI will be dismissed, and there's going to be no objection to spousal abuse deferral on the domestic violence.
All right, Mr. Swinski, is that the offer?
It is, Your Honor. I think that's appropriate.
Okay, Ms. King, may I address your client to check in with her?
So
You may, Your
Lauren
Honor.
Silverstein.
Thank you. All
A
right,
moment.
Also jail
Miss-
credit.
yeah,
Barb.
Barb, we're hearing you.
I'm trying to mute her, but I cannot mute.
All right. Barb, you're in as Teresa, but we're unable, we're hearing you crosstalk on our current open case. All right, Ms. Peters, good morning.
Good morning.
Your attorney has indicated the offer. The prosecutor has said that's what he understands the offer to be. And your attorney is recommending that you follow the offer. Did you hear and understand the offer that was outlined on the record?
Yes, I did.
Are you planning on following your attorney's advice and entering a plea to the offer?
Yes, I am.
All right, would you please raise your right hand where I can see it? Do you solemnly swear or affirm testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
All right, you can put your hand down now. Has anyone promised you anything more than what we've talked about on the record or threatened you in any way to get you to plead to these 2 charges when you really do not want to?
No, Your Honor.
Are you right now under the influence of any medicine, drugs, or alcohol that's confusing you?
No, I'm not.
If you enter this plea, you'll be waiving some valuable rights. I'm going to show and share on the computer screen a copy of the advice of rights form. Would you tell me when you see it on your computer screen? It should be there by now.
Yes, I do.
I'm going to slide it down to the bottom, and on the lower right-hand side, there is a signature, and I want to see if that is yours.
Yes, it is.
Did you read this form and understand it before you signed it?
Yes, I did.
You realize that by entering this plea, you'll be waiving all of the rights that are outlined on that form?
Yes.
And do you waive those rights?
Yes, I do.
How then do you plead to count 1 of domestic violence with the understanding of a recommendation or no objection to spouse abuse deferral against Levi Butler? Do you plead guilty, not guilty, or stand mute?
Guilty.
And then there's an added count 3. It's not on the complaint right now, but the agreement is that you would plead to operating while visibly impaired. Count 3. How do you plead to that? Guilty, not guilty, or stand mute?
Guilty.
On or about April 11th of this year, were you at an address at North Meridian Road, Lincoln Township, Midland County, Michigan?
Yes, I was.
Were you there with Levi Butler?
Yes, I was.
How do you know Levi?
He's my ex now.
You have faded out on me just at the last when you were explaining who he was. He's your
Boyfriend.
ex-boyfriend. So you did have a boyfriend-girlfriend relationship with him at some
We
point.
did. Yes.
What happened on April 11th, I think, makes you think you're guilty of domestic violence against him?
I was driving my car and he swerved the wheel on me as I was driving down the expressway twice, going about 70 miles per hour. And I hit his arm to make him stop swerving the wheel.
Ms. King, are you waiving any defenses that this was self-defense in order to keep her from crashing her car? Or is there another set of facts that I could hear that would get us to the factual basis?
Your Honor, we would waive the self-defense.
Okay. And at that time prior to driving, had you consumed alcoholic beverages?
Yes, I did.
And would you agree with me that your ability to drive was impaired by the alcohol?
Yes.
Okay. If I presume all of that's true, Ms. King, have I complied with the court rule and had an adequate factual basis?
You have, Your Honor.
Do you agree, Mr. Shawinski?
I do.
All right. I'm going to find that the plea has been made knowingly, understandingly, voluntarily, and accurately. Will enter in the records of the court as domestic violence pursuant to the spouse abuse deferral. So we'll need to get information regarding that. and to the count 3 of operating while visibly impaired, count 2 operating with while intoxicated is dismissed. We'll set this over for pre-sentence investigation. Because of the domestic violence and a recommendation for spouse abuse deferral, I want a full PSI done. Can we get the sentencing date and time, please?
Yes, Your Honor, that'll be August 2nd at 9 a.m.
August 2nd at 9 a.m. All right, we'll be adjourned. That will be by Zoom. We'll adjourn until that date and time. Is there anything we need to do with the bond, Ms. King?
No, Your Honor.
Anything we need to do with bond, Mr. Schwinski?
No, Your Honor, thank you.
All right, Ms. Peters, it looks as if looks like you are doing well on bond. I do see some concerns that you have regarding the victim, in this case, making contact with you and not ordering anything from the victim. You're just going to make sure you keep yourself safe.
Okay, thank you.
All right, thank you. We'll be adjourned.
Thank you, Judge.
Your Honor, I have a person in here by the name of Lori. Can I have you tell me your name, please?
Oh, Adam Shafer.
Your Honor, that is my client, and I was wondering if we can go into a breakout room for a brief consult.
We will put you in a breakout room with your client.
Thank you, Your Honor.
Shafer, you just need to accept the invitation to join the breakout room.
Yep.
Your Honor, I'm bringing in an LG Stylo 6. I'm still looking for Mr. Dusso's client.
Your Honor, I did just communicate with her. She's trying to connect. She appears to be having difficulties.
Okay, let's find
I have
out
an
who that is.
LG Stylo 6. Can you tell me your name, please?
Jeremy Lafrey.
All right, we'll go with the Lafrey case then.
Sir.
Mr. Burton, are you with us here? I see Mr. Branson, the city attorney. This is his 2 cases.
I am here.
All right, Mr. Branson?
Yes, Your Honor, I am as well.
All right. Calling the files of City of Midland versus Jeremy Lafrey. This is file 20-1405 OT and 21-0172 OT. Counsel, identify yourselves for the record.
James Branson on behalf of the City of Midland.
Leland Burton for Mr. Lafrey, Your Honor. Your Honor, there was an original plea offer from the city attorney on this case. It involved my client tendering a plea of guilty or no contest to charges in circuit court. At the time of taking the plea, my client failed to provide an adequate factual basis, and the matter was set for trial. So we're not in a position to take advantage of the city attorney's offer since we didn't fulfill the condition preceding to his offer.
All right. So what are we going to do with these cases, Mr. Branson?
Your Honor, there still remains no offer at this time. These are ones rather old, 12/7/20 with a violation date, and 2/10/21, improper plates, no valid ops.
Your Honor, I would have no objection should the court set these matters for bench trial, and no objection to them being held, if not simultaneously, near simultaneously.
Mr. Branson, do you have any objection to a bench trial?
No, Your Honor, I do not.
How long should I set it for if I do both cases at the same time?
I'll need 15 minutes, Your Honor.
Okay, so we'll set it for 1 hour just to make sure that Mr. Burton has the opportunity to thoroughly and completely cross-examine the police officers, the other witnesses. How long should we set it out for? A couple of weeks?
That's fine. Is that
That's
okay?
fine, Your Honor.
July 9th,
right.
Your Honor, which is a Friday,
Friday, July 9th, at what time?
9 a.m.
All right. That will be in person. So, Mr. Lafrey, you need to be at the Midland County Courthouse at district court level, July 9th at 9 a.m.
Okay.
Okay, we'll see you then.
Yep. See you later.
Thank you. We continued.
Thank you, Mr. Burton.
Thank you.
Your Honor, I do have a phone number appearing. I will bring that in. have a phone number ending in 2952. Could you tell me your name, please?
Azar Karami.
Thank you.
Okay. Mr. Dusso, you ready to proceed on the two cases?
Yes, Your Honor.
All right, calling the cases of the City of Midland versus Azar Karami, file 20-1320 OM and 20-1254 OM. Counsel, identify yourselves for the record.
James Branson, on behalf of City of Midland.
Good morning, Your Honor. Joseph Duso on behalf of the defendant.
All right, today's time and date set for settlement conference. Do we have a resolution in this case, Mr. Duso, or do we need to set for trial?
At this exact time, I think we need to set this matter for a trial.
All right, bench trial or jury trial?
Your Honor, I'd actually request a jury trial on this matter.
All right.
Now, we would ask the cases be consolidated if we could, please.
All right, well, we'll do is set a settlement conference date and a jury trial date. Katrina, can we give it the dates for the cases?
Your Honor, the jury trial will be September 2nd. At 9 a.m. And a settlement conference will be August 31st at 8:45 a.m.
Okay. Bond will be continued to that time, and we'll be adjourned on this case, on both cases.
Very
Thank
good.
you.
Thank you.
Thanks.
Now, there is a third case for her, and I believe she is representing herself. The last
I
I
don't
heard.
have that on schedule. Katrina, did we miss one?
Your Honor, I don't have it on my schedule.
Let me see. Let's take a look.
Your Honor, I apologize. That is now, I look at my notes, that's scheduled for July 8th at 8:10 a.m. for a pretrial. So thank you.
Oh, okay. All right. Thank you.
Sorry, it stopped me, Your Honor.
All right. Ms. Karami, we're all set until you have one case where you have not hired Mr. Dusso, and that is in July.
No problem. Thank you.
Thank you. We'll be adjourned.
Eric
Thank you,
Fairchild,
Your Honor. I believe that does conclude the city matters until I think 11:15 for Bradshaw.
Okay, thank you.
Great. Thank you, Your Honor.
I have Mr. Househill here, and I have Mr. Fairchild. It'll be just a second, he's connecting.
All right, calling a case of the people of the state of Michigan versus Eric James Fairchild, file 21-0440 SD. Counsel, identify yourselves for the record, please.
Atia Duso on behalf of the people.
Stephen Houseel on behalf of Mr. Fairchild.
All right, today's time and date, it says for a plea. Is there a plea offer in the case, Ms. Duso?
Your Honor, the offer, I believe, would be to plead for the defendant to plead guilty to impaired. I think we had come to an agreement on that.
Okay. Is there a restitution that needs to be addressed?
There would be a $20 restitution request for the blood draw.
And that's it? Okay.
Yes.
The reason why I failed to stop at a stop sign. Okay, I thought I read a crash. All right, Mr. Houseel, the recommendation, it looks like from the probation department is that your client has been participating, and so they're recommending me sentence him to probation with standard terms, a 12-month initial determination, eligible for removal after 6 months. So, is your client ready to proceed to the plea?
Yes, Your Honor. I would note that, as you mentioned, there's a stop sign violation. There were associated with this 2 civil infractions. And Mr. Fairchild has admitted responsibility to those 2 civil infractions, which were combined with this file, by the way. And he has paid the fines in full. So those matters should be, at this point, those civil matters, traffic matters, should be closed.
Okay. May I address your client then about the plea?
Yes, Your Honor.
Good morning, Mr. Fairchild.
Morning, Your Honor.
Your attorney is recommending that you accept the offer he's negotiated for you for an operating while visibly impaired. The words visibly impaired and impaired driving, they're the same. Visibly impaired, just the full name for the charge. So your attorney is recommending that you accept that offer. Are you planning on following his advice?
Yes, Your Honor.
All right, if you would, please raise your right hand where I can see it. Do you solemnly swear or affirm testimony you're about to give is the truth, whole truth, nothing but the truth, so help you God?
I do.
Thank you. You can put your hand down now. Has anyone promised you anything more than what we've talked about on the record or threatened you in any way to get you to plead to this charge when you really do not want to?
No, Your Honor.
Are you right now under the influence of any medicine, drugs, or alcohol that's confusing you?
No, Your Honor.
If you enter this plea, you will be waiving the rights that are outlined on an advice of rights form. Looks like you signed an advice of rights form. I'd like to share that with you to see if your signature's on the form. It'll be just a second before it shows up. It should be there right about now. Can you see it?
Yes. Yes, Your Honor.
Is this your signature on that form?
Yes.
And you signed this because you've read it and understood it. Is that correct?
Yes, Your Honor.
Do you realize you're waiving all the rights on this form if you enter this plea?
Yes, Your Honor.
And do you waive those rights?
Yes.
How do you plead to an added count 2 of operating while visibly impaired? Do you plead guilty, not guilty, or stand mute?
Guilty, Your Honor.
On or about April 9th of this year, were you operating a motor vehicle on Jefferson Street in the city of Coleman, Midland County, Michigan?
Yes, Your Honor.
Prior to driving that day, had you consumed alcoholic beverages?
Yes, Your Honor.
And Ms. Dusso, did the blood results come back?
They did, Your Honor. It was a 0.195.
All right. And Mr. Alstio, may I use those results as part of my analysis?
You may.
If I do, have I complied with the court rule and had an adequate factual basis?
We're satisfied, Your Honor.
Ms. Dusso, same question.
Yes, Your Honor.
All right. I believe I have as well. I find that the plea has been made knowingly, understandingly, voluntarily, and accurately. Will enter in records of the court as count 2, operating while visibly impaired. Count 1, operating while intoxicated, will be dismissed. Mr. Alstio, allocution on behalf of your client.
As you pointed out, Mr. Fairchild has been actively pursuing treatment, counseling since the day of this event. He's been cooperative and successful in all of that. He's had no positive alcohol or drug tests during this entire time. And I think that certainly indicates his commitment to addressing this and to moving forward with his life and staying sober. Thank you.
Right. Mr. Fairchild, anything you wish to say on your own behalf before I sentence you?
No, Your Honor.
Right. The notes that I have show that this was a fail to stop at a stop sign. You admitted to drinking at Bomber's Bar in the town, Portsville sobriety tests. The evaluation was completed at J&A prior to coming to court. It was noted by them that you had a mild to moderate alcohol use disorder. The recommendation was by them for you to do 10 to 12 sessions and that you're participating in them weekly. Your tests are appropriate. The reason for the probation length is that you do have the 2005 possession of marijuana and MIP, the 2006 impaired driving, and the 2009 marijuana charge, and the 2015 leaving the scene of a crash. And so I think that the recommendations for 12 months for probation is appropriate. I'm going to follow it. I will need to read this into the record. It is the sentence of the court that you will pay $75 crime victim rights fee, $50 state assessment fee, $300 in fines, $475 in court costs. There'll be $20 to reimburse the prosecutor for the blood draw fee. You will be placed on 12 months of reporting probation. You are eligible for an early discharge in 6 months pursuant to the new statutes if all your probation terms are complete and you have no violations within 3 months prior to that time period. You shall attend and complete any counseling program to which your probation agent refers you to pay the fees, and provide proof. You shall not use or possess alcoholic beverages, illegal drugs, mind-altering substances, recreational marijuana, or any derivative of recreational marijuana, including CBD or THC-infused products. You shall not enter any bars or places where the primary purpose is to serve alcohol, and you shall not enter any place where recreational marijuana is dispensed, grown, manufactured, or used. You shall submit to random observed alcohol drug testing with no dilute, abnormal, or adulterated test as directed by probation and pay the fees, and you'll serve 93 days jail, credit for 1 day served. The balance will be suspended as long as you're complying with the terms. You have 21 days to appeal this sentence, 14 days to request a court-appointed attorney to help you appeal this sentence. Otherwise, your probation officer will be in touch with you, and then you'll need to make your payment or payment plan after speaking with her. Anything else we need to place on the record, Mr. Halcyon?
No, Your Honor.
Ms. Dussault?
No, thank you.
All right, Ms. Fairchild, we're all set for today. Thank you.
Thank you, Your Honor.
Mr. Hyde, I see you're back. We are going to recall the cases or actually call the cases of the People's State of Michigan. There's only one case. People's State of Michigan versus Adam Shafer, file 210456 SD. Counsel, identify yourselves for the record.
Okay, I do so on behalf of the people.
May it please
And
the
Mr.
court,
Hyde,
Michael Hyde. Yes, Michael Hyde on behalf of the defendant, Adam Shafer.
All right, today's time and date set for settlement conference as well as a bond violation. Mr. Hyde, were you aware of the allegations regarding the bond violation?
They were contained in the notice of hearing, Your Honor, but I didn't receive any substantiating evidence of those at all. So,
all right. Ms. Huffman, good morning. I see that you're here. Are you able to hear us?
Good morning. Yes, can you hear me okay?
Hear you now. Are you the agent acting as pretrial services coordinator for the defendant, Mr. Shafer?
That's correct, Judge.
And you filed the request for bond violation.
I did, Your Honor, and I just wanted to note right off the bat, I was reviewing that this morning, and I had a typo on the memo. The violation indicates that he missed a test on May 24th and May 14th. It should actually be June 14th. So May 24th and June 14th.
May 24th and June 14th. So they're missed tests.
Correct.
And how were you made aware of those missed tests?
Via Cordant, which JNA uses.
Okay. And is it some kind of an email that's sent to you or some kind of notice that was sent to you?
Your Honor, we actually have access, direct access online to the Cordant Sentry lab system where all the test results are available.
All right. So, Mr. Hyde, it looks as if it's an online portal for which she logs into, and there's indications of June 14th, not May 14th and May 24th. So you probably had different dates, at least one of them. It was listed as May 14th versus June 14th. So one more recently, about a week ago, and then May 24th. You still need to meet with your client regarding that allegation?
if I could, Your Honor, I want to clarify those.
Okay. So we'll put you back into breakout room, and when you come back, we'll recall the case once more.
Appreciate that, Your Honor.
Your Honor, I do have Mr. Bobolek here who's set for 10:45, and I do know Mr. Durance is here.
All right. If there's no objection, we'll go to those cases then. Ms. Deuce, are you on the Bobolek cases?
Yes, Your Honor.
I don't know what's going on with your microphone, but it's been fantastic today. I can hear you every single time.
And I'm not even that close to my computer today. I don't know.
No, it is as clear as it's ever been. So we didn't have one incident. So
I'll take it.
All right, calling two cases: the People's State of Michigan versus Gary Michael Bobolek, file 210383ST and 210449SD. Counsel, identify yourselves for the record.
Atea do so on behalf of the people.
Peter Durance on behalf of Gary Bobolek, who is appearing from Zoom at my office.
All right, today is the time and date set for settlement conference on both files. Has there been a plea agreement reached in the case, Mr. Durance?
Yes, there has, Your Honor. So we received the blood results for the 21-0449SD. We reached an agreement with the prosecutor. It's basically going to be plead as charged to both counts, the operating while intoxicated first and the open intox. And then the other offer was for plead guilty to the open intox and admit responsibility to civil infraction for no proof of insurance if defendant shows he has valid proof of insurance, and he should have that with him today.
Okay. So in the second file, plead as charged. In the first file, 1 misdemeanor, 1 civil infraction.
That is correct, Your Honor.
And it's your advice that your client accept those offers. Is that correct?
That is correct.
Did he bring a copy? Well, may I ask your client? I see him there. So
yes, Your Honor.
Mr. Bobolek, did you bring in a copy of your insurance to your attorney's office?
Yes, sir, I have it. I forgot to grab it out of the vehicle.
Can you go grab it? That way Mr. Durant can verify it. So that way we'll set place. We'll wait for you.
Yes, sir.
All right. Thank you. Ms. Duso, I presume if Mr. Durant sees it and gets a copy to us that you're willing to accept that as satisfaction for that plea?
Yes, that's fine, Your Honor.
Okay. Guess we'll recall the case then of the People, State of Michigan versus Adam Donald Shafer, file 210456 SD. Mr. Hyde, have you had an opportunity to talk with your client regarding the settlement conference as well as the bond
Yes, Your Honor.
violation? And what is your client's intentions?
Well, settlement conference, we have still some discussion to do on that. I will be in touch with Ms. Duso. We haven't received a plea offer or anything from her office. I have some information to receive from Mr. Shafer prior to making an offer of our own. So on that, I'd like an adjournment. On the bond violations, by way of explanation, the May 24th was like the very first time he was supposed to drop, and he admits to just completely forgetting about it. It just slipped his mind. The June 14th failure is he actually, he tells me he got out of work at 8 o'clock that night. He made it over to the facility to do the drop about 10 or 15 minutes before they closed, and he just was not able to produce a sample. But he did go, he did go.
So he acknowledges with explanation.
Yes.
Okay. Mr. Hoffman, how has Mr. Shafer's performance been other than these 2 incidences?
Your Honor, to give you a rundown of the history of his testing, he actually first tested on May 15th. That result was, it detected marijuana, however, it didn't, the lab did not confirm it above the cutoff level. So he tested on May 15th, May 24th, he missed the test. I called him the next day on the 25th. He was stuck at work out of town that day and unable to do a makeup test. So what we did is increased his testing at that point. June 1st, the system is indicating that he submitted a test positive for marijuana. And then June 10th, it indicates that testing is still in progress. I have an email into J&A because I'm not quite certain what the issue is with that sample. It seems like I should have those results back by now if they were submitted on June 10th. So I'm uncertain about that. June 14th, he missed the test. I never heard from him with regards to his issue of not being able to produce a sample. He never called me the following day or anything. So I haven't discussed the testing with him again after that. He did submit a test on the 18th, 4 days ago, which the results are still pending. So the testing is my main concern. His substance abuse evaluation was scheduled for June 2nd initially. I think he canceled and rescheduled that. So that's set to take place tomorrow on the 23rd.
And I presume that Mr. Shafer does not have a medical marijuana card.
He advised me he does not.
All right. What I'm going to do is adjourn this for 2 weeks. That gives approximately 2 weeks that Mr. Hyde can see if he can secure an offer, and also we'll have the results back from the most recent tests to make the determination on the bond.
Your Honor, I can speak to the offer. The only offer that he has or is going to get is that we would dismiss the open intox if he pleads to an OWI second. His blood draw result was a 0.345, so there's not going to be a further offer from our office.
0.345?
Yep.
Wow, okay. All right, so I don't see that he was charged. Was he charged with the open intox? Let me take a look.
Yes, he was. That was count 2, Your Honor.
Okay, it's not showing. Usually shows on my. Usually shows on the docket, but it did not. All right, Mr. Hyde, we'll give.
By way of
go ahead.
correction, Your Honor,
Yes.
the laboratory results that were submitted to my office show a BAC of 0.245, not 345.
Okay.
But
well, that would take away my wow. But 345 is 245 still 245 still very high, but 345 is.
Your Honor, I guess now I have a question. I've got the lab results pulled up on my computer screen. If Mr. Hyde would like to, I could screen share if you'd like to see them. I want to make sure we're looking at the same things now.
Go ahead.
And can you see the document?
yes, I can.
Is that the
Is that
same?
not
as-
what you-
Oh,
That can't be right.
yes. I saw that one, and Ms. Dusso, I don't know if you can see the document that I'm holding up on my end, but this is from the police and the warrant, and it says 0.245. So there's a discrepancy there, but
From the police and what?
well, this is
warrant.
this is the yeah.
I can't see. Hold on.
This is the supplemental incident report from the Michigan State Police.
So, Katrina, could you take down what she's sharing, and then we'll be able to
that's
figure.
that's simply the report that that they do when they receive the results. My guess would be that the trooper who typed that made a typo, as we can clearly see on the actual laboratory report that it is a 0.345.
All right. Well, what we'll do is I'm scheduling this out for it's about 2 weeks, Katrina. If we get
July
the date and time.
July 13th at 10:15, Your Honor.
All right. Well, Ms. Hoffman, are you available that day to be able to testify necessary?
I believe I would be, Your Honor.
Okay.
What was the time?
10:45.
10:45.
10:15, Your Honor.
Oh, 10:15?
Yes,
All
sir.
right. 10:15. All right. We'll be adjourned then on this case at this time.
Thank you.
Thank
Your
you.
Honor.
Thank you.
All right, Mr. Bobolek is back. Mr. Durant, did you get an opportunity to take a look at his insurance documents?
I did, Your Honor. I have it in front of me. It is currently effective.
Okay. Is there any chance that you could have that scanned and emailed to? Ms. Dusso said upon your presentation of it, it would be enough, but just for the files afterwards, if you would be able to do that.
Understood, Your Honor. I'll put it over on my scanner right now, and I will send it to Ms. Dusso's office as soon as we conclude here.
All right. Ms. Dusso, are you satisfied so we can take the plea in Mr. Bobolek's case?
Yes, Your Honor.
All right, Mr. Bobolek, we're going to unmute you here.
Has to hit the space bar or hit accept.
Yeah, you'll have to respond somehow, Mr. Bobolek, to the request.
I can go fix it for him, Your Honor, if you would like.
Yeah, if you would wouldn't mind assisting your client
He's got it,
regarding
Your
that.
I think I got it.
All right.
And Barb, I was looking at the spreadsheet for the pretrial services report, and I did not see Mr. Shafer's information. I may have missed it, but I didn't see that on there. And if we could make sure for the next time it was there, I would appreciate it.
Your Honor, we did get an email from Miss Hoffman this morning.
Okay, well,
The updated version, just so you know, when I pulled it up this morning.
Okay. All right, Mr. Bobolek, your attorney is recommending that you enter these pleas. Are you planning on following his advice?
Yes, sir, I do.
Please raise your right hand where I can see it. Do you solemnly swear or affirm testimony you're about to give is the truth, whole truth, nothing but the truth, so help you God?
Yes, sir, I do.
You can put your hand down now. Has anyone promised you anything more than what we've talked about on the record or threatened you in any way to get you to plead to these two cases when you really do not want to?
No.
Are you under the influence of any medicine, drugs, or alcohol that's confusing you?
No, sir.
If you enter this plea, you'll be waiving some valuable rights. You need to make sure you understand those rights. Those rights are the right to remain silent, not ever silence used against you, the right to be presumed innocent until proven guilty beyond a reasonable doubt. You would have the right to a trial by jury, or if you, your lawyer, and the prosecutor agreed, by bench trial. Mr. Durance, are you appointed or retained?
Retained in this case, Your Honor.
You would be waiving the right to request a court-appointed attorney in both files. You would be waiving the right to confront your accusers, to call witnesses, and to testify. Do you understand each of these rights?
Yes, sir, I do.
In order for me to accept your plea as outlined, you would have to waive these rights. Are you planning on waiving these rights?
Yes, sir.
Okay, we're going to start with the first case of the no insurance and the open intox. How do you plead to count 2 of having open container of alcohol in your vehicle? Guilty, not guilty, or stand mute?
Guilty.
All right. So the next one, if in a criminal case like that one, you plead guilty or not guilty. On a civil infraction, you're either responsible, meaning you violated the law, or you're not responsible, meaning you didn't violate the law. How do you plead to not having proof of insurance, which is a civil infraction? Do you plead responsible or not responsible?
Responsible.
Okay. On March 17th, were you driving a motor vehicle on Sturgeon Road in in Larkin Township, Midland County, Michigan?
Yes, sir.
Did you get pulled over by the police?
Yes, sir, I did.
Did they ask you for your driver's license, registration, and proof of insurance?
Yes, sir.
Were you able to give them proof of insurance on that day?
No, sir, I was not.
Did they look in your car and see that you had open alcohol in your vehicle?
Yes, sir.
What did you have?
Behind me, I had a open container of twisted tea, I believe it was.
It was
Behind
an
me.
alcoholic beverage?
Yes, sir.
And it was in the cabin of your vehicle?
Yes, sir, it was.
All right. Mr. Durance, if I comply with the court rule and had an adequate factual basis?
Yes, Your Honor.
Do you agree, Ms. Dussault?
Yes, Your Honor.
All right. I find that the plea has been made knowingly, understandingly, voluntarily, and accurately will enter in records of the courts as count 2, open intox. Count 1 will be dismissed, and I'm fining you $210 for the insurance. I'm going to set over the sentencing on this case. I don't see any notes from pretrial regarding this case, and so I'm going to set this over for a pre-sentence investigation along with the operating while intoxicated case. We get a sentencing date and time, Katrina?
Yes, Your Honor. That would be August 2nd at 11 a.m.
August 2nd at 11 a.m. That will be the sentencing date. All right. We're going to be adjourned on that case. Bond will be continued in its present form. We're going to go now to file 20-1449SD. Sir, I'm going to remind you that in this file, you are still under oath. All of the rights that I went over in your previous file apply to this one. Do you remember those?
Yes, sir.
And do you waive the rights to the trial in this case?
Yes, sir, I do.
Okay. How do you plead to count 1 of operating while intoxicated? Guilty, not guilty, or stand mute?
Guilty, sir.
How do you plead to having open alcohol in your vehicle? Guilty, not guilty, or stand mute?
Guilty, sir.
On April 11th, were you operating a motor vehicle on Saginaw Road, the Citgo parking lot in Lincoln Township, Midland County, Michigan?
I was there, sir.
And in your cabin of your car, did you have an open container of alcohol?
Yes, sir.
What did you have in your car on that day?
I think a half pint of Fireball.
All right. And I presume you were drinking the other half of Fireball prior to driving. Would that be true?
Yes, sir.
And would you agree with me that you, in fact, were intoxicated at the time that you were driving?
Yes, sir.
Let's do so. Is there blood draw results that we received?
It was 0.297.
0.297. May I use that as part of my analysis, Mr. Drance?
Yes, Your Honor.
If I do that, have I complied with the court rules and had an adequate factual basis?
I believe so.
Do you agree, Ms. Dusso?
Yes, Your Honor.
All right, I believe so as well. I find that the plea has been made knowingly, understandingly, voluntarily, and accurately. Will enter in the records of the court as operating while intoxicated and had an open intox. We'll set this over for pre-sentence investigation. It will be the same date and time as the other case. Bond will be continued in the files. Will be adjourned. Thank you.
Thank you.
Your Honor, I have Sean Loveless, but he is not present, sir.
Mr. Drance, have you had any contact with Mr. Loveless today?
It's actually Mr. Duke, sir.
I'm sorry, Mr. Duke?
No, Your Honor. He didn't show up last time on June 7th either.
Okay. Well, then I'll call the case and we'll move on. So it's the people of the state of Michigan versus Sean Loveless, file 210583SM. Counsel, identify yourselves for the record.
Thank you, Patrick Swinsky for the people.
Daniel Dupree on behalf of Sean Loveless.
All right, today is the time and date set. We had a show pause set. There was a petition and bench warrant, and the defendant has failed to appear. Mr. Duke, you've not had any contact with your client recently.
I have not, Your Honor.
All right. Bond is revoked already. There is immediate bench warrant. Will be adjourned on this case. Thank you.
Thank you.
I'm going to step off with 3 minutes until our next hearing.